Breaking Down the Law is sponsored by Battle-Born Injury Lawyers.
All right, we're breaking down the law this week and discussing lawsuits coming as a result of the coronavirus. This week, the family of a man who passed away from the virus filed suit against his employer, Walmart. The wrongful death suit alleges Walmart ignored the symptoms he and others had. He died just 2 days after being sent home. With so many workers exposed to the virus here in the Valley, could we see something similar happen in Nevada, with so many workers potentially exposed in our community? Let's break it down right now with attorney Matt Hoffmann with Battle-Born Injury Lawyers, that is. Matt, it's so good to have you with us. So let's just jump right into it. What rights do workers have against their employers in these situations? And do we have something similar in Nevada?
Well, and I think that, you know, obviously we have a similar situation, whether it's grocery stores or what have you, of employees being exposed to COVID-19. There have been complaints, throughout the nation, quite frankly, of employers not providing, allowing people to wear masks or gloves or not following the CDC guidelines or OSHA guidelines. And that's what's being alleged in this lawsuit. So I think that you're going to see claims based upon it, and rightfully so. The real question is, in this case, you've got a lawsuit for wrongful death that's a traditional lawsuit, like a negligence lawsuit. And it's for the family of an employee who's suing his employer, Walmart. So the reason I bring that up is that normally these kinds of situations are compensable as a workers' compensation claim. So it's a little strange to me that they're trying to get around workers' compensation.
So, Matt, in that situation, the issue is not so much providing a safe workplace, but does that rise to the level of a company intentionally harming him? Intention being the word that we're focusing on.
Yeah, and that's what the lawsuits allege, and I think artfully and for a specific purpose is, look, they're trying to get around being limited to just workers' compensation benefits. And Illinois is no different than Nevada in that if you can prove that an employer intentionally harmed you, then they're not protected by what's called the exclusive remedy, where workers' compensation is the only avenue in which you can sue your employer. In Illinois, I'm not going to say that I'm knowledgeable about all their laws, but I can tell you in Nevada, that's going to be an uphill battle. The Supreme Court in our state dealt with a situation where somebody, was exposed, had a heightened risk of becoming, ill or injured because of the lack of preparation of their employer, and the Supreme Court said that's not enough. That's not enough to rise to the level of intentional conduct. Usually intentional conduct is really extreme situations, like an employer literally assaulting an employee or something. So I think that you could see these lawsuits, but I think that legally speaking, it's going to be very difficult to get anything more than workers' compensation.
Very interesting. And, we're kind of running out of time here, Matt, but, it will be interesting to see how this, moves forward, and if we'll try to see more people making these claims. And no doubt we'll be bringing you back in to kind of help us sort through it and eventually see how it pertains to us here in Nevada. Matt Hoffmann breaking down the law for us as he does each and every week. We appreciate you, and we hope you and your family, of course, are staying well and healthy. We'll see you next week.
Thanks for having me. Stay safe.